your family hits a wall. Your accounts can become frozen. How often do they all agree? Probably not often. The only reason not to have a durable power of attorney is that you don't know you need one. In the last video, we covered your will and your trust as part of an estate plan. The will covers what happens when you pass away. The trust covers what happens when you pass away. But neither of them cover what happens if you're still alive and you can't act for yourself. That gap, the period between incapacity and death, is where most California families face their worst legal and financial crisis. And it's that gap that two other documents exist specifically to close. Today we're covering both of those documents. I'm Jayson Elliott. I'm a California attorney at Bay Legal, and I've spent years helping real estate investors and medical professionals protect what they've built. Today, I'm covering two documents that protect you while you're still alive. These documents are for you. The trust and the will are for your family, your children, or the charities that are your beneficiary. The durable power of attorney and the advanced healthcare directive. What they do, when they become active, who should have them, who should hold them, and what happens to your financial life, to your medical decisions if you don't have it. There is an incapacity problem that even my estate planning clients, my trust and will clients, don't want to plan for, or they simply just don't plan for. When people think about estate planning, they think about death. They think about dying and who gets their assets. Who's going to raise my minor children? What happens to my property when I die? And that thinking is absolutely correct, but it's not complete. Because there's another scenario that estate planning has to address. One that's statistically more likely to affect you before death does. And that's your incapacity. A stroke, a serious car accident, a medical procedure that goes wrong, a progressive illness, any condition that could leave you alive but unable to manage your own affairs, make your own financial decisions, or communicate your medical wishes. In that scenario, a will is useless. It doesn't activate until you pass away. A trust can help with asset management, but only if your successor trustee also has the legal authority to step in. And without a durable power of attorney, your family may have no legal mechanism to act on your behalf. This is not a theoretical issue. It's not a theoretical case. The CDC reports strokes affect nearly 800,000 Americans every year. Traumatic brain injury affects over 1.5 million Americans every year, and dementia can affect 1 in 8 Americans over the age of 65. The question is not whether incapacity planning matters, the question is whether you've done it. The lack of incapacity planning can devastate your assets prior to your death. The durable power of attorney and what it does. A durable power of attorney is a legal document that authorizes somebody else, somebody called your agent or sometimes referred to as attorney in fact, to act on your behalf for financial and legal matters. The word durable is critical. A standard power of attorney sometimes becomes void if you become incapacitated. A durable power of attorney remains in effect even after you become incapacitated. It's specifically when you are incapacitated, that is when you need it the most, and it's exactly when it will. Your agent, who you select under a properly drafted durable power of attorney, can access your bank accounts, pay your bills, manage your real estate, file taxes, they can handle your business affairs, and make financial decisions on your behalf without involving the courts. Without a durable power of attorney, almost none of that is possible. Your family hits a wall. Your accounts can become frozen or at least inaccessible. Your property can't be managed and your bills can end up going unpaid. The only legal remedy in this situation without the power of attorney is a conservatorship. And a conservatorship is everything that the power of attorney is not. A conservatorship requires filing a petition in the probate court. It requires notice to family members. It requires a court investigator, and it requires a hearing before a judge. It typically takes 3 to 6 months to establish, and that's if nothing is contested. Legal fees alone can run $5,000 to $15,000 or more if it's contested, and once established, the conservatorship has to file annual accountings with the court for as long as the conservatorship is in place, every year supervised by a judge. A durable power of attorney, drafted properly as part of your complete estate plan, costs a fraction of that, and it can be in place today. The mathematics here is not complicated. The only reason not to have a durable power of attorney is that you don't know you need one. Now you know you need it. What your power of attorney must cover. Not all power of attorneys are equal, and in California, a poorly drafted power of attorney can be as useless as no power of attorney at all. California financial institutions, banks, brokerage firms, title and escrow companies are understandably cautious about accepting powers of attorney. They have potential liability if something is not correct. I've seen clients present a power of attorney at a bank and be turned away because the document was just more than a few years old, because it didn't include specific language authorizing that specific particular transaction, or because it was a generic form downloaded from the internet and rather properly executed California document. It doesn't include everything that they need for that transaction. A durable power of attorney for a California property owner or investor needs to specifically authorize real estate transactions. It needs to specifically authorize banking transactions, trust operations for your revocable living trust, business entity management, and your tax filings. Generic language is not enough. The document needs to name these authorities explicitly. Now, and this is a point I want to make to real estate investors here in California, if you happen to be managing a 1031 exchange and you become incapacitated in the middle of that process, the IRS does not care. There's no mechanism for extending the deadlines. The 45-day identification window does not pause for medical emergencies. The 180 days exchange period does not extend because you're in the hospital. Without a durable power of attorney that specifically authorizes your agent to act in a 1031 exchange on your behalf, including identifying replacement properties, signing the purchase agreements, and coordinating with your qualified intermediary, that exchange will fail. The deferred gains will become immediately taxable, and on a large exchange, that tax liability can be catastrophic for the entire estate. I'm not raising this to frighten you. I'm raising it because it's entirely preventable. That properly drafted durable power of attorney with the 1031 exchange authorities costs nothing extra to include. It just has to be in the document. One last California specific note. If you hold real estate property in an LLC, which is oftentimes a great idea, your power of attorney needs to authorize that same agent or a different agent to act in your capacity as the manager or member of the LLC. Otherwise, your agent may have access to your personal accounts, your personal real estate, but will be completely unable to manage the transfers, the LLC real property holdings, the LLC bank accounts, the LLC operation. So we need to make sure that's covered as well. Again, it doesn't cost anything extra. We just need to know to put it in the document. We've covered a lot of the legal basis, the legal reasons, but the most important decision around a power of attorney is the assignment of the agent. This is a personal decision. The legal mechanics of a power of attorney matter, as we've shown, but nothing's more important than who you name as your agent. Your agent has significant power over your financial life. In a broad power of attorney, your agent can access your accounts, sell properties, manage your business interests, and make binding legal commitments on your behalf. So you're entrusting that person with your entire financial life. That's important because if you need care, the ability to access your financial life is how you will logistically pay for your care. The criteria I recommend for every client: your agent should be someone you trust completely, someone who is organized, capable of handling financial, legal matters under pressure, someone who is accessible both geographically and practically, and someone who won't become overwhelmed or paralyzed by this additional responsibility. A spouse is obviously the most common choice, and often it's the right choice, but it's not always. If your spouse would be emotionally devastated by your incapacity, they may not be the right person to also be managing your real estate transactions, your business affairs, at the same time they're dealing with your incapacity. So there's a couple options. Name a successor agent, a backup agent in case the primary agent is unable or unwilling to serve. This isn't being pessimistic, it's just proper planning. When these things happen, sometimes family members become preoccupied with the actual event and unable to manage the external necessities. Finally, you need to review that agent designation every few years. The person who was the right choice 10 years ago might not be the right choice today. You might not even be in their life today. Relationships change, circumstances change. The next document is the Advanced Healthcare Directive. This document speaks for you, and this is the document most people, maybe not most people, a lot of people try to avoid talking about, try to avoid dealing with because it's unpleasant subject matter. It's apparently easier to talk about death than it is incapacity. Where the durable power of attorney protects your financial life during an incapacity, the Advanced Healthcare Directive gives instructions for your medical decision. It tells your doctors and your family what you want when you cannot speak for yourself, again, due to incapacity. In California, a comprehensive Advanced Healthcare Directive has two components. The first is the healthcare power of attorney. We're back to the agent again. We name a healthcare agent who can make medical decisions on your behalf. But those medical decisions are framed by the second component of the Advanced Healthcare Directive, which documents your specific wishes regarding life-sustaining treatment, artificial nutrition, pain management, end-of-life care, even funeral arrangements. Together, those two components answer both questions a medical team faces when a patient cannot communicate. Who decides, and what does the patient want? Without an Advanced Healthcare Directive, California law provides a default hierarchy for medical decision-making. Clearly, the spouse is first. Then come adult children, then your parents, then your siblings, and then other relatives. If your family agrees, this hierarchy sometimes works. Families, under the stress of a medical crisis, don't always agree. And if we look at those people that the state identifies, most of those have multiple people in them. Spouse, probably only have one. The adult children, depends on how prolific you were. Then your parents, there's two people in that category if they survive you. And the siblings, that can be depending on how prolific your parents were. Other relatives, who knows how many. In each of those groups, parents, children, siblings, other relatives, how often do they all agree? Probably not often. So we're giving a broad bucket of people the ability to make your decisions together. That usually doesn't work really well. Adult children have different views. A spouse and an adult child from a previous relationship, probably going to have conflict. Parents may disagree with your domestic partner who has the most knowledge of what your wishes are, but isn't legally recognized as your next of kin unless they're in that healthcare document. The Advanced Healthcare Directive allows you to name the person you want, the person who knows you, the person you trust. Your directive eliminates all of that disagreement. When the family disagrees and there's no directive, the medical team may be forced to seek a court-appointed conservator for healthcare decisions. That process takes time that a patient in a medical crisis may not have. Your directive eliminates all of that. It names one person to speak for you, potentially a backup person, and it tells that person and the medical team exactly what you want. Okay, now I want to speak directly to physicians and medical professionals watching this. You know these documents. You've completed them or reviewed them with your patients. You've sat at a bedside, explained to a family what an Advanced Healthcare Directive is and why their loved one should have one. You've seen firsthand what happens, especially in an ICU, when there's no directive on file and the family cannot agree. You've seen the conflict, the delays, the distress of the medical team, and especially the administration, trying to honor a patient's wishes when those wishes were never documented. Does your own family have instructions for you? I ask that question not just to make a point, but I ask it because I know the answer is often no. Studies have shown consistently that healthcare providers, including physicians, complete Advanced Healthcare Directives at a rate no higher than the general population. The knowledge is there, the intention is there, the document's just not there. If you're a physician, a surgeon, a hospitalist, you carry more risk of a sudden incapacitating event than most people recognize. You work long hours, you're exposed to infectious diseases. The stress of a medical practice has real psychological consequences. Please complete your own healthcare direct. And while you're at it, let's make sure that durable power of attorney addresses what happens to your practice, your professional corporation, your patient relationships, your staff, payroll, and your call schedule if you are suddenly unable to work. California law has provisions for the management of medical practices during a physician's incapacity. They are not automatic. They require planning. We help physicians structure that planning at Bay Legal, and it is some of the most important work we do. Okay, let's bring this back to the complete picture. You have 4 documents in a complete California estate plan. You have your will, you have your revocable living trust, your durable power of attorney, and an Advanced Healthcare Directive. Your will and your trust address what happens at your death. Your power of attorney and your Advanced Healthcare Directive address what happens during your life if you're incapacitated. Together, they cover every scenario: death, incapacity, sudden or gradual, expected or not. Remove the power of attorney and Advanced Healthcare Directive, and you have a plan that only works if you die cleanly. No period of incapacity. No medical crisis, no time when someone needs to act on your behalf before you're gone. That's not a complete plan. It's only half a plan, and if your incapacity causes devastation to your estate, there's no plan. The 4 documents are not separate legal things. They're one system, and the system only works when all 4 are in place, up to date, and coordinated with each other. If you don't have a durable power of attorney, or you don't have an advanced healthcare directive, or if you have them, but they're really old, you haven't reviewed them for the last 3 years, you signed them because your doctor at Kaiser told you should sign them before a surgery 15 years ago, this is exactly what we can help you with at Bay Legal. These documents need to be current. They need to be properly executed under California law and coordinated with your trust in your will. A document that was drafted 15 years ago may not reflect your current wishes, your current agent, or current California law. I've linked a free California incapacity planning checklist below. It walks you through both documents and helps you identify what you have, what you're missing, and what needs to be updated. If you want to sit down and walk through your specific situation, we offer consultations and I'd be glad to meet with you. Next week, I'm going to cover entity planning, LLCs, S-Corps, C-Corps, and how to structure your business assets to protect what you've built. If you own investment property, a medical practice, any other operating business, this is one you don't want to miss. Subscribe so you don't miss it, and we'll see you on the next one.